Just days ago, a federal court of appeal ruled the previous Liberal government's use of the Emergencies Act to clear the convoy protests in 2022 was unjustified and violated the Charter. Here to discuss the ramifications of the decision is Wayne MacKay, Professor Emeritus at Dalhousie School of Law and an expert in constitutional law and the Charter. Good to see you, Wayne. Thanks for coming in.
Nice to see you.
The court was definitive. The Trudeau government's use of the act was unreasonable, it said. It's certainly a significant ruling. Tell us why.
It is a significant ruling, well, and first of all, because the Emergency Act is a very significant occasion when powers get centralized in the government, then they can do a lot of things. But it's also significant because, of course, the earlier commission had said it was legal, and now the second court, the Court of Appeal, is saying it's not. So it is very important.
Certainly puts this current government, future governments, on notice.
It does do that for sure. Now, the court was clear to say there are occasions when you can use it, albeit it's an extreme thing, but that they put a very high standard when it was appropriate to use that act.
The Canadian Civil Liberties Association fought this tooth and nail.
Yeah.
Obviously, they're celebrating it. They've said it means that government can't govern by decree behind closed doors. Explain that.
Well, in a way, that's right. Perhaps a little overstatement. It's true. And in a time of crisis, war, that kind of thing, you do have to have very quick action. So much of what's done now by legislation and a slow debating process is done by executive order behind closed doors. And so that they're right about that. And they're right, except that they can do it if they meet the act and if they don't violate the Constitution. And that's where the civil liberties and others are saying, well, you didn't do it in the right way, and you didn't pick the right occasion to do it.
Was it clear to you that was the case?
It was not clear to me, to be honest, because for one thing, when we look back on a crisis, whether it's COVID or whatever it is, it looks a bit different 3 or 4 years later than it did in the midst of it. And it wasn't that clear to me, or I think many others, that we were in fact not in some kind of a national crisis with the convoy in Ottawa and the various blocking of pathways between the U.S. and Canada. So I don't think it was crystal clear, although the judges seemed to think it was fairly clear that they did not meet the high threshold, because they don't have to establish that there is a national emergency. They have to establish they had a reasonable basis to think there was a national emergency. So even if after the fact they say, well, really, that wasn't such a big deal, it still could be valid.
Canadians don't have a lot of experience with the Emergencies Act. There was another Trudeau government. Those of a certain age will remember the FLQ crisis in Quebec when the War Measures Act was brought in. Can you compare the two at all?
Well, you can, and that's a very important comparison to make. First of all, kind of ironic, Pierre Trudeau and Justin Trudeau. But in 1970, of course, Pierre Trudeau declared the War Measures Act, which was more restrictive and didn't have as high a standard. In fact, basically, it couldn't be challenged by the courts later, but that was rewritten in 1988 by Mulroney into the current version, which does set the much higher standard. But it's similar in a couple of ways. In retrospect, the FLQ crisis was probably not as big a national deal. I mean, a person died, and it was certainly a big deal at the time, but not only really in Quebec. And here, the courts are making kind of the same argument that, yes, there was a lot of unfortunate things happening in Ottawa, but was it really a crisis, they're saying?
Was it ramped up perhaps more because it was on the doorstep of the federal government?
Well, I think that's a good question for sure.
The Carney government is not taking this up the chain, not appealing. What does that tell you?
I hadn't actually heard that, but that's interesting. I knew they were thinking about it, but if they haven't, I guess that...
Well, that's the initial thinking, is that it's not going to...
Oh, okay.
Not going to be.
All right. If they don't, I guess what it's thinking is that the court made a pretty convincing case. It was a unanimous judgment of all 3 Federal Court of Appeal judges, and in a very long 500 and some paragraph decision, gave lots of evidence why they thought that the government did not meet the test.
We're hearing a lot from the U.S. White House talking about the American Insurrection Act, and that the president there might bring it in to suppress the dissent that's taking place in Minneapolis. Is there any correlation between our act and theirs and what's happening there?
Well, that's a really interesting and important analogy because there's some correlation. First of all, according to the Trump administration, there is an insurrection of sorts going on, and if the state can't handle it, they're threatening to move in and do it under this federal emergency legislation, or the government emergency, same as here. And in the Canadian situation, Ontario was having great difficulty dealing with the problems in Ottawa and the other issues, so there's that parallel. I think perhaps where the parallel breaks down, the kinds of cases even contemplated in the Canadian Act are much more difficult. As the court said, it has to be a really high standard. It has to be national in scope. It has to be a threat to human life and security. It has to be extremely high order threat that can't be handled otherwise. It would appear that in the U.S., the Insurrection Act is a bit more open-ended, and as we see with all too many things with President Trump, his own interpretation is a pretty broad one of what he can do.
Sure, and it can change day by day. Wayne MacKay, thank you very much for that. We'll see if, in fact, the Canadian government does decide to do something about this.
Exactly, because sometimes the first thoughts aren't the final thoughts.
Well, we certainly know that. Thank you very much for coming in.
No problem.
We appreciate your perspective as always, and we will take a time out. Still a lot ahead, so stay with us.